My name is Lieutenant Colonel Lee Roger Wolfgram, and I am a story.
Welcome to the bunker. Hey everyone, welcome back to the Colonel Channel. I am your self-proclaimed commander, Lieutenant Colonel Lee Roger Wolfgram, and I'm coming to you with another P. Diddy update. Guess what? The last video I was giving my thoughts about what I think the defense should do, and guess what? The next day, they did exactly what I had suggested they do. And the last time we were talking about Diddy Sean Combs getting bailed out, I asked this question, and I want you to think about this because it's an important question. And that is, do you believe that a person is innocent until proven guilty? And as a defense attorney, I'm going to take that position. By no means misunderstand me. I think that if these allegations are true, this guy, Sean Combs, should go to prison for life. Very clearly. Okay? But with the facts as they are, we're going to take a look at that because he has now filed documents. There's a new judge on the case, and there's a new run at bail conditions. And so let's cover that. Okay? Now, before we get into that real quickly, he had asked the court for a gag order. He was asking for people to not discuss this. He wants to keep the publicity down, and that's so that he can get a fair trial. That was the underlying sort of motivation for it. That was denied. Now we'll talk about the new documents and his new bid for release.
There's some big news coming in. He was denied that gag order. The unprecedented relief that Combs seeks on this motion is unwarranted. So no, you can't just silence all the accusers, all the victims, all the lawyers. It doesn't work that way.
Okay, so I'm just going to play a little bit of my last video so you can see my passion about this issue of coming up with conditions for a person that is presumed to be innocent. As much as it may pain people and myself, the true fact is he has not been convicted of anything. And what we're finding out is maybe the evidence isn't as much as it's blown out to be, yet to be determined.
Okay, so before we get into this, so here's the point. So they say, well, he's got so many resources that he could just use his resources and he could abscond. He could leave the country. He could escape jurisdiction. And the public's not safe. Well, come on, Judge, use your head. You can do something that whatever your concern is about public safety, make a rule about that. It doesn't have to be in the jail. If you want to have all of his calls go through a switchboard so he can't threaten anybody, hey, you're the judge. Make that the order. If it is, he can't leave the house at all. Hey, it's your order, Judge. And if it's about these, well, how does this occur? He does have the resources, so the government can't have it both ways. Oh, he has the resources so he could just abscond, when actually what he's doing is he's putting up his resources to create the conditions for the judge to be able to do the two things the judge needs to do: assure his return to court and to make sure that the public is safe.
Okay, so new judge, new opportunity to file a motion regarding release conditions. The judge said submit it, and they have.
Lawyers for Sean Diddy Combs now making another request for him to be released from jail. Attorneys for the hip-hop mogul proposed a stricter set of conditions this time, including around-the-clock security monitoring and very little contact with basically anyone else but his lawyers. The request for a $50 million bond amount remains the same. Combs was arrested back in September after being indicted on federal sex trafficking charges. He has pleaded not guilty.
But now he's presenting a $50 million bail package. Could he get it?
Sean Combs is currently locked up in a federal detention center awaiting his criminal trial, but he has taken every opportunity to bail out.
I'm Anjanette Levy. Sean Combs is not giving up on his fight to be released on bail as he awaits trial on sex trafficking charges. His request for release has been denied twice, so he's hoping the third time will be a charm. Combs has pleaded not guilty to racketeering and sex trafficking charges. He's been in custody at the Metropolitan Detention Center since September.
As certain relevant new information has come to light since the detention order, Mr. Combs intends to file a renewed motion for pretrial release on conditions with an updated proposed bail package in the district court. The fact that since his arrest back on September 16, 2024, and his indictment on sex trafficking, racketeering, conspiracy, and transportation to engage in prostitution charges, he has been locked up behind bars. He's locked up at the Metropolitan Detention Center out in Brooklyn. Now, he has been denied bail, pretrial release, multiple times. Sean Combs' team filed a motion asking the Second Circuit Court of Appeals to actually suspend his appeal of the bail decision, meaning don't do anything with it yet. Under the law, we call this holding the appeal in abeyance, meaning don't do anything yet. We want to first have the opportunity to argue the bail issue in front of the new judge overseeing Sean Combs' criminal case, Judge Arun Subramanian, because he had said at a prior hearing, if the defense has any bail application that they would like to raise, then the court will certainly hear it.
Okay, so new judge, new opportunity. But here's what's coming up. So you may remember the CEO of Abercrombie and Fitch, and he was also accused, and there are allegations very similar. At this point, there are civil cases that are talking about minors, but as far as the indictment, the actual official charging document, minors aren't involved. So this analysis is going to be based on the fact that there have not been any minors that have been a part of the current legal criminal case. And I want you to think about this. Is it fair for one guy to get release conditions and not another guy if both of those are presumed to be innocent?
And Combs' lawyers argued that the prosecution, they didn't meet their burden to hold Combs until trial. And then in a follow-up brief later on that month, they doubled down on this. They wrote in that filing, Mr. Combs is entitled to release, which has been granted to many similarly situated defendants, including just yesterday, a CEO accused of sex trafficking dozens of young men, including through witness intimidation. The government's request for detention is not based on any genuine risk of danger or obstruction. It is based on a desire to punish Mr. Combs. So that was in reference to how federal prosecutors in New York had charged the former head of Abercrombie and Fitch, Mike Jeffries, with sex trafficking, and he was granted bail. So an interesting comparison there.
Combs' lawyers also point to former Abercrombie and Fitch CEO Michael Jeffries, who's also charged with sex trafficking, and the case includes allegations of witness intimidation. Jeffries posted $10 million in bail and is on GPS monitoring.
The prosecution opposed this. In their letter to the court, they doubled down on the allegations against Combs that he is violent, that he abuses and sex traffics women, that he possesses weapons. So they're really honing in on the allegations in the indictment. And they wrote, there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. As reflected by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight despite the conditions offered by his counsel.
Okay, so here's where I think they lose credibility. So you just heard him. The government is saying there are no conditions that could assure he's going to return to court and face the charges, or that the public is safe. My view, that is lazy, and it's simply not true. Are you telling me that a learned mind of a judge that has been doing this for years and years and years, with an unlimited budget, it's not limited by the budget of the state or the criminal justice system, but on his own cost, at his own expense, this should be a playground for a judge to go, I can think of many things that we could do to protect the public or to assure that he returns to court. And so, why not? That's what this argument is about. This argument is about not whether or not he has more money and that way he should be treated differently. I personally think that it needs to be in proportion to what your assets are. So for a guy who has $100, you know what? $50 is a lot. For a guy that has $100 million, $50 million is a lot. And that's how I believe that bail should be applied. It's an individual thing for each individual, and the whole purpose is to set the conditions to make sure the public is safe and they return to court. That's it. The jury's going to decide guilt or innocence.
That when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary.
Now we're going to talk about risk of flight, and we're going to talk about the package that's being put together. But definitely there are conditions that would prevent him from fleeing. And there definitely are conditions that would keep him from injuring anybody, and we're going to hear about those.
He left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. Now, as we know, government agents, they arrested him. Nonetheless, they didn't allow him to surrender. But the point is that he voluntarily showed up, showing he is not a flight risk. He is cooperative. He should be granted bail.
This is a very important part. When I have a client, for example, that has a warrant, I always recommend, look, let's turn you in so that we remove the government's argument that you're a risk of flight. Why would you, if you're going to take off, if you're going to flee, it's kind of contradictory then to turn yourself in the first place, right? If you're going to run, you would run when you could run. So I think he did the right thing. I think counsel advised him to do that. And I think it totally goes against the idea that he would not return to stand and face the charges.
Combs' attorneys also explained that Combs, he knew the Southern District of New York was investigating him for months. And his lawyers say, look, we tried to reach out to the prosecutors since March to talk about the case, to talk about the investigation, but the prosecutors, they didn't respond. But after the infamous raids on Sean Combs' properties in March, Combs, they say, actually surrendered his passport to his lawyers. This was back in April. And from there, his lawyers say, you know what else, Judge? We kept telling prosecutors where Combs was going. We kept them up to date on his travel plans, what he was doing. So he surrenders his passport. We are letting the prosecutors know where he's going. Again, he's not a flight risk. Also, they say, Combs never left the country, even though he has a private plane. And on top of that, Combs was making efforts to sell that plane, all trying to show that he was acting in good faith, that he's not a flight risk, that he can be trusted.
And if you watch this channel, you know that I am a pilot, and I have addressed this in the earlier video, and then I get people, well, he could take off from a private runway, or he could do all these things. All true. But here's what you do. You make the condition that the aircraft needs to be located at an airport that has an air traffic control facility 24 hours a day. That airplane can't even get on the taxiway. If it was even attempted, there would be cop cars out in front of the wheels. And it's not like a car. You don't just smash into cars with an airplane and keep on going. As soon as you hit something, that airplane is grounded. So this whole idea of the airplane and the comments I got last time about, oh, I don't know what I'm talking about, he could just do it from a private runway. No, true, if that were the case. What I'm suggesting is it goes to an airport where it probably already is that has a 24-hour air traffic control facility. It's not going anywhere. With regard to the next item here, and that is the evidence. So remember, they executed these search warrants, all of this stuff that they recovered from the search warrants, and yet when it comes to evidence that's been presented so far, it's pretty weak. And there may be, you're starting to see a defense emerge here where there might be motives on the parts of certain people for making the allegations. So I don't necessarily believe that at all, but what we see is the formation of the defense. It's starting to take hold.
Here, with Sean Combs, the government's basically saying, look, court, just take our word for it. Look at the allegations in the indictment. Look at what we're alleging. That's enough to show that he's engaging in obstruction. Combs' lawyers say the government has no actual evidence. They didn't present anything that he's been doing anything wrong. Just presenting the allegations in the indictment, Sean Combs' lawyers say, that's a problem. You can't just rely on that.
And why can't you just rely on that? Because the government could write down anything they want on a piece of paper, and it sort of becomes like, in this particular case, it's almost like this is a self-authenticating document. We put it on paper, so you have to go by that. No, it requires evidence. We don't let the government just put things down on paper. You have to actually have some evidence here.
The evidence makes clear that the government's case in this is thin.
They say the government has the actual communications. They could describe them for the court, but they don't.
Additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim. And the new evidence confirms the government's obstruction and witness tampering allegations at the initial bail hearings lacked a factual basis.
That they say the government failed to prove by clear and convincing evidence, which is kind of a middle ground standard, that Combs has to be detained before trial.
In his new filing, he's calling the government's case thin based on the evidence his lawyers say they've received in discovery.
New evidence received in discovery from the government undermines the primary basis of which the government initially sought, and Judge Carter ordered detention.
Tellingly, the government does not point to, nor can they, any conversation Mr. Combs has had with a potential witness since he had knowledge of the criminal investigation where he pressured any witness to change their story.
Okay, so now we're going to talk. So we talked about the evidence, okay? They haven't really put forth anything. They've given discovery, at least the first batch of discovery, and defense counsel is going, where's the beef? And the government's saying, well, we put it down on a piece of paper. Look right there. Not good enough. Not good enough to keep somebody in this very terrible, very dangerous facility. And it's not really about Sean Combs. It's about you. If you were accused, wrongly accused, someone who didn't like you made some stuff up, somebody who wanted your money made some stuff up. If we just take what people put on paper and we go with that, you're not safe. If Diddy Combs isn't safe, you're not safe, because that is what defense counsel does. In this judicial system, we are the keepers of the Constitution. Whether or not the client is guilty, not guilty, the jury will determine. That's not our job. Our job is to make sure that the process is fair. And that means when things like this, like there isn't any evidence and a person is presumed innocent in custody, defense counsel should jump up. Defense counsel is doing that because it is required to keep the system and the government from overbearing on all of us.
He has given it all up. Mr. Combs proposes an updated bail package that is far more robust than the previous proposal, as well as other bail package routinely approved by the courts. The proposal package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. The updated proposal conditions, which include home detention, strict 24 security monitoring, near total restrictions on ability to contact individuals or their counsel, will reasonably assure the appearances of Mr. Combs as required in the safety of any person and the community.
It was a $50 million bond, $50 million, co-signed by Sean Combs and other members of his family.
He will consent to provide pretrial service random access to the residence. His passport will be surrendered. Following family members have also surrendered their passports. Here we go. Counsel will continue efforts to sell his airplane. Defendant shall submit to testing for substances if required. Yada, yada, yada.
This would be in addition to home confinement with GPS monitoring. And they argue that this would satisfy any concern the government would have that Combs is a risk of flight or a danger to the community.
Full home detention at his residence in Miami. The house that they didn't raid. Idiot King Combs. Or suitable location, New York, with GPS monitoring. Counsel will travel to his location for any in-person meetings and have counsel meetings via video. To the extent Mr. Combs' travel is necessary to attend court or pre-approved medical appointments, see how they can get away with that, pre-approved medical appointments. His travel will be restricted to the southern and eastern districts of New York and southern district of Florida. He must pay all or part of the cost of location monitoring, 24/7 monitoring by qualified security personnel approved by the government and pretrial services. Well, that's interesting. That's interesting because previously it was his team, the team that had all those weapons and things there. I don't think they were trustworthy. He'll have no access to telephones or the internet except for during calls with counsel to be arranged by the security personnel. So now he's given up saying, you can have monitoring at my house. Just let me be at my house so I can properly do this. Restrict all visitors except for counsel, pre-approved list only consisting of specific family members with the consent of pretrial services and the government. Family visits will be scheduled only with pretrial services prior. Security personnel will monitor family visits. I mean, to be honest, if this is how it really reads, and it's like you guys can pick the security, they will be there always, they will monitor everything. That's pretty massive.
And he would agree to weekly drug testing. And at one point, they also said that his internet and cell phone usage would be taken away too.
If Your Honor wants something more different, we can do whatever Your Honor thinks is necessary. So he's really like, dude, I'll do whatever it takes.
Because the government had said, look, it's not fair to have a two-tiered justice system where Sean Combs can stay free on sex trafficking and racketeering charges because he has the money, the financial resources to turn his home essentially into a private prison, whereas you have a defendant of lesser means who couldn't put forward that kind of bail package, and they would be denied bail, and they're locked up while waiting trial. Sean Combs' attorneys responded to that and said, we are offering this package, these conditions, because Sean Combs is wealthy. The government said he's a flight risk and a danger because he has the money, the power, the resources. So the reason this bail package looks like this, the reason it's so expensive, the reason he's essentially turning his home into a private prison is because this would be the only way to ensure all of the concerns the government has. They wrote, the government can't have it both ways. It cannot use Mr. Combs' wealth as both a detention sword and shield.
Okay, so now the problem is, let's just say he's not released and he's in the MDC in Brooklyn. This is a huge impediment for him to prepare his defense. Think about this. So on federal cases, typically you're going to get terabytes and terabytes and terabytes of information. These federal investigations go on for a long time. There's a ton of evidence. The last time I had a federal case, it was so much evidence, we had to hire a company to sort it just so I could find the things that were relevant to my client in this federal case. So think about that, but you're in a cell and you can't review all of that evidence. In the cell, effectively, you can't talk to your lawyer. I don't even know if they would have the computer backup to be able to put the discs in the computer. So every time somebody's in custody, it's a terrible disadvantage in preparing for their defense because defense counsel can only be there for periods of time. And the expectation would be, as you're preparing for a trial, is your client's got all the same evidence that the jury's going to see. They're down there with their pencil and their notepad and their highlighter. They're going through that stuff. So they have those discussions with their attorney so that there is an effective strategy for the defense. When you're in custody, don't have a computer, can only talk to your lawyer for as long as he can be there, and then what do you have after that's gone? Where's your laptop? You see what I mean? It's a really unfair advantage, and it's especially, to me, it's especially offensive for someone who is presumed to be innocent and the court has just kept them in custody. It's hobbled their defense, and even if they're innocent, it is a much more difficult defense.
Mr. Combs' release on the proposed conditions is necessary so that he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense team's needs, the current arrangement makes trial preparation impossible, as evidenced by the recent multi-agency sweep of the facility and resulting lockdown.
Mr. Combs' current condition of confinement infringed his constitutional rights to participate in his defense. Given the government's unamended estimate of the amount of discovery in this case, its unique format, including voluminous video, photographic evidence, Mr. Combs' release on the proposed conditions is necessary so that he can review the discovery and prepare for trial. Despite the MDC's best efforts to facilitate the defense team's needs, the current arrangement makes trial preparation impossible, as evidenced by the recent multi-agency sweep of the facility, resulting in lockdown. The Bail Reform Act and the Constitution demand more. Accordingly, Mr. Combs moved to reopen the prior detention decision, a request for release in the proposed update.
Okay, so at this point here, I want to make this point. The defense, as I predicted, is going to be one of consent. And so long as minors are not a victim in the federal case, in the criminal case, consent could be a defense. These are just swingers. They like to do stuff that other people don't do, but it's not illegal activity, or whatever illegal activity, it doesn't rise to this level. Like if people are doing drugs, those are not life sentences. Those are not anywhere near the same. So now we're about to see how the defense emerges. So a big part of this is going to be consent, as I predicted. And another part of this now is going to be the motive. So now defense emerges, that this is a scorned lover or someone who has a issue with me. And because of all the money involved, it's sort of taking this like somebody wanted money from me, and because I didn't give them money, now these federal charges come. Interesting defense, but you see it starting to emerge. It's deflecting. There's a financial motive for these things. That the victim in this case is only a victim in this case because I didn't buy their book and buy the rights to their book. You can see that kind of in the background here.
MDC, the Metropolitan Detention Center, that is not a place you want to be. It is violent. It is dirty. I mean, it was just the subject of an interagency sweep by federal authorities who confiscated all of this different contraband.
Combs says he needs to be released on bail because the conditions at the MDC where he's being held just aren't adequate enough for him to prepare for trial. They cite a recent sweep of the MDC where drugs and weapons were seized. That didn't have anything to do with Combs.
This case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged. The sensationalism surrounding his arrest has distorted the bail analysis.
By this, now, I do think he's a threat. I do. At the same time, it's like he has the right to defend himself, and it's really hard to do it in jail. Now, obviously, for us who don't like Diddy, we're all like, yay, but I'm more for due process and the rights because we got to do it the right way. And what is the evidence they're actually showing and using to prove this? That's what's up for debate.
There are simply no conditions that would ensure that the defendant's efforts to obstruct and tamper with witnesses will stop.
Okay, so when they say that, again, there are no conditions. That is a lazy answer, and obviously the defense team has come up with conditions, and those conditions, I believe, are adequate. I don't see how he's going to get out of a 24-hour monitoring situation with security that's approved by the government. All of his communications are limited. I don't see it.
There doesn't appear to be a second sex trafficking victim. Combs's lawyers have maintained the threesomes between Cassie, Combs, and male sex workers were consensual. Combs's lawyers also point to Cassie Ventura and information about her that's included in the discovery. Combs's attorneys say so far they've received 23.5 terabytes of discovery. That's a lot of material, and they say it supports their position. The new material demonstrates that the government previously misrepresented the weight of the evidence, and it undermines the government's claim that Mr. Combs presents a danger. They also say the discovery includes information that is redacted that refutes the government's core sex trafficking allegations. Much of what Alex Shapiro, the attorney for Combs, writes about Cassie is redacted in the motion. But Shapiro says the evidence shows Cassie's allegations of sex trafficking and sexual assault were a way to obtain a financial windfall from Combs 5 years after their relationship ended. In fact, Shapiro claims Cassie Ventura, in the spring of 2023, needed money to support her family, so she started writing a book about her relationship with Sean Combs, and then had a lawyer contact his lawyer to see if he would buy the exclusive rights to it for $30 million. Combs's lawyers claim Ventura only filed a lawsuit claiming she was sexually assaulted and sex trafficked after Combs refused to pay up. Of course, Combs settled the suit within a day, and then Combs's troubles with the feds began, and an avalanche of other civil suits followed.
All these civil cases can be stayed, meaning just pushed and waited until the criminal case is, done and over with. The criminal case is the important one. You don't want to throw it all out. It's like the Michael Jackson case is the prime example of that, where they made him have to settle he had to face these civil cases first before the criminal trial. And that was one of Michael's biggest regrets. We're going to talk about that in the documentary I have on him. So if you don't know all the facts, stay tuned. It's going to come out next year. But he was like, look, I don't want to give up all our stuff so then they can come at me even harder and try to discredit me with this and that and that. That sort of changed the rules. And so, yeah, criminal cases usually come first. It's the important one. And then after that verdict, it can help or hurt, the defendant.
Okay, so we've kind of heard all those arguments, and it sounds like a defense is starting to come together. A little bit more optimism about the possibility of release. And there is, by the way, an appeal that's being held in abeyance right now. So even if the judge rules against them, they're all locked and cocked to take it to the appellate level. It sounds like there may be some financial motives here for the allegations against him. And so from a defensive standpoint, I don't know that he could really be poised better. His arguments are solid. The evidence is weak, at least at this point, according to the discovery that's been given to the defense. So these are all good things. But what does this dumbass do? He reports, he says he's going to turn himself in. He's in New York, and he has a white party. This is one of these things when I have clients that I've got everything locked and stacked in a way that's the best it can be right now. Then they go out and they do something that completely undermines that entire preparation, that entire posture. And, well, I'll let you decide. You tell me.
Illicit conduct, they say, was happening even when he came to New York right before he was arrested. Aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Some of this conduct has even taken place since the defendant arrived in New York City, allegedly to sit it out and wait to be arrested. The defendant's conduct is demonstrably not cooperative and indeed highlights his inability to abide by the law.
Okay, so now you see. The defense counsel has this thing lined up about the best they could. They've got a new bail package put together. They've got some idea that maybe there's some motive for false allegations. There's weak evidence, and there's a dangerous jail. And what does he do? He has a freak off. Come on! What is his lawyer supposed to do about that kind of stuff? Like, don't you get it? You're looking at a potential life sentence. Take it back a notch, guy. Give your lawyer a chance to just stop keeping up with you and get ahead of this thing. Well, those are my thoughts for the moment. On the next video, it's going to be a little bit different. So if you watch this channel, you know that it's not just legal things, although that's what my editors say, that the largest audience is with legal things. But one of the things I wanted to do in the beginning was to create a military-minded, friends of the military, patriotic sort of a community. And I'm going to have a video coming up here on Saturday where we're going to talk about those kinds of things. So be sure to watch that. And we've got a contest coming up where you can enter your own video. Watch on Saturday and you'll see the rest. Until the next time, this is Lieutenant Colonel Lee Roger Wolfgram, Wolf 6 from the Wolfgram Worldwide Headquarters, out here.